I want to transition a little bit into the what exactly you think this new standard of review, or sort of clarified standard of review that the majority has put into this opinion, is going to result in. Like, what are the laws that you feel won't stand up to scrutiny under this standard?
Well, the first thing to say is that while the approach that the majority lays out makes it much more difficult for judges to put their thumb on the scale, you cannot stop courts from doing that if they really want to. And we saw this famously with the Fourth Circuit's decision on the so-called assault weapons ban in Maryland, where the court sort of said, well, this is a weapon that is unusual in nature, and therefore it doesn't qualify for Heller's in common use protection. And to sustain this, they said all sorts of things about the AR-15 platform that aren't true. And really, they were talking about, an M4 or some sort of select fire or, fully automatic weapon. And that hasn't been reviewed by the court. So, if a lower court really wants to play games with this, of course, what the majority opinion does is make it far easier for the court now to dismiss those arguments. It makes it more difficult for the lower court to ignore Heller because Heller is fleshed out. So, I think it's worth saying that this is not some magic fix, but it does make a difference. What do I think is going to happen? I think what Thomas has tried to do here is what Thomas should have done here, which is treat the Second Amendment as if it's actually a constitutional right. And, I've had this conversation with a lot of people who disagree with me on gun control. Forget the law, just on gun control as a political matter or a legal matter. And, they will say, well, yes, but, it's just different, isn't it? And, okay, yes, and certainly where I'm from it is, but if it's a constitutional right and we treat constitutional rights seriously, then no, it's not different. And I think what Thomas has tried to do is remove some of the avenues whereby judges are able to say, yeah, the Second Amendment, but this is just too important. And the most obvious effect that might have is if there is a case on, say, assault weapons, so-called, or high-capacity magazines, and providing that there is some analogy between those weapons and weapons of the founding, or the original definition of arms covers them, which I think it does. Contemporary definitions of arms in the 18th century explicitly mentioned carbines, for example, and the AR-15 is one. I think this makes it more difficult to ban those weapons outright. I don't suspect we're going to see a much stricter approach toward carry for the reasons I've already outlined. I think this is about as far as the court is going to go or should go. We already have the decision in Heller that lays out that the Second Amendment protects an individual right, and that the ban on handguns is unconstitutional, and so on. The next frontier is obviously, well, what's allowed and what's not. And this probably does make it more difficult for jurisdictions to ban those weapons. But the only caveat there is the Supreme Court seems to take one of these cases every 15 years. So
right.
I might be 50 by the time it happens.
That's exactly what I was saying. I think that's a very important point to make here. It does seem like under this new clarified standard, which really the court is just saying is the same standard they used in Heller, but they're kind of spelling it out now more explicitly. That a lot of laws that just are not long-standing, basically, if they came about starting in the 20th century, they might have a significant problem passing this new test. So yeah, assault weapons bans, magazine limits, gun sales permitting, perhaps, gun licensing, those sorts of things. You could see a lot of those face new scrutiny. But I think ultimately it does really boil down to, like, is the court going to actually take cases to enforce this new standard? Because that's been the problem up until right now, is that this is what everybody argued was the standard. Kavanaugh put it, sort of articulated it, I guess, in the most influential way. But the Heller standard on the gun rights side, this has been what people thought the court was saying the whole time, and it didn't really matter because the court wouldn't take any of these cases where lower courts upheld gun restrictions based on this two-step standard that
right.
It has now trashed. So I think it will come down a lot to whether they actually take more cases, right?
Right. I think that's right. I think there's a couple of reasons that they haven't taken more cases. One has changed, the other hasn't. The first is obviously the makeup of the court. This is a different court than the one that decided Heller and that decided McDonald. So there's probably more votes now to take these cases, and there's probably more confidence that if they take them, they will come out in a clear fashion.
Right.
The thing that hasn't changed is that some of these questions are actually really difficult. So I don't think that the case that the court looked at today was particularly difficult. I don't think Heller was particularly difficult. I do think it would be difficult for the court to start micromanaging this. For example, is 12 hours of training fine? Is 18 hours of training fine? Now, a year of training is too much. But, other than outlining broad strokes, you don't want to have every gun question being decided by judges.
Yeah.
And as such, I think some of the cases that people want them to take, including which weapons are allowed, are actually quite hard to deal with. Heller has an in common use standard. I think the AR-15 is very clearly protected. So this is in no way to undermine that idea. But there's also a provision in Heller that talks about unusual weapons. What is that?
Yeah,
that's tough. And I don't think they want to get too much into that, in the same way that in the 60s, they got tired of having to decide what pornography was and wasn't, and eventually said, we're not doing it anymore.
Right. I mean, and Heller, to me, it's still very much a compromise ruling. I mean, you've got, I just said that a lot of laws that didn't exist until the 20th century are going to come under new scrutiny because of the standard. But the court has already said something like the National Firearms Act, or alluded to the National Firearms Act in Heller, and said it was presumptively constitutional because it's, I guess, automatic weapons are unusual and dangerous, at least in it's not, it wasn't a major part of the ruling, but it was something that was mentioned as, like, here are some laws that we don't think would be struck down by the Second Amendment. And the National Firearms Act, which didn't happen until 1934, was among them. So,
yeah, I mean, the problem with the in common use standard is, although I understand the logic for it, it can ultimately become circular, right? In the sense that, so tomorrow, let's say that somebody invents a smart gun. Now, we associate smart guns either with this sort of James Bond movies, because they don't really exist, or with Democratic politicians who are obsessed with them and they really want this to be the future, and they always talk about getting rid of all the guns that aren't smart guns and so on. But you could theoretically have a state that says, okay, well, as the smart gun has just been invented that actually works, we're banning it. And under Heller's in common use standard, that might be all right. Yeah. Which, is that really what the Second Amendment is supposed to do? I don't know. That's a tricky one. So yeah, I take your point, but I think that really underscores the problem, which is that the court, I think, wants to get involved in broad brush decisions that make it clear what the Second Amendment means and what can on a macro basis be prohibited and what can't. And beyond that, I think it wants to leave the question to state and federal legislatures, and I think it's right to do so within bounds.